Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this Honorable Court. Please.
Good morning. Call the first case, please.
Joel C. Riley et al. Versus Hector Jaramillo et al.
We'll hear from the appellant.
May it please the court, Roger Jennings from the Bradley County Bar. It's been a while since I've been up here. It's good to see you all. I represent the plaintiffs below, the appellants Joe Riley and wife. This is an action appealed from the McMinn County Circuit.
You want to reserve any time?
I reserve 3 minutes.
3 minutes, okay.
This was an action filed in the McMinn County Circuit Court. Judge Sharp accused himself, and Judge Hollingsworth of the Hamilton County system took over the case. This case was brought for the purposes of enforcing restrictive covenants against property purchased by the defendant, Hector Jaramillo and wife. The plaintiff insists in the lawsuit that we are entitled to the imposition of restrictive covenants based upon express restrictive covenants set forth in the deed where Mr. Riley obtained his property from the common grantor, and alternatively under the theory of negative reciprocal easement. I have this voice problem, Your Honor, I apologize, but the parties filed competing motions for summary judgment. The trial court ruled in favor of the defendant and stated that the plaintiff could not prevail primarily on the language in the Riley deed where he states that the statement or identity of the first parties was not sufficiently defined. I'll come back to that in a moment, but Walthall's acquired a 174-acre tract from their parents by gift back in 1955. They did absolutely nothing to develop this property until 1986 when they made a conveyance to Raymond Axley. In that conveyance to Axley, Walthall specifically restricted the use of that property. It's very detailed restrictions set forth therein, and specifically provided the purpose of the restrictions to maintain the tone of the community, to protect the value of other property owners within that community. That same year, December of 1986, the Walthalls conveyed a 42-acre tract of land to Sharp for the purposes of developing what was called Wheatland Hills subdivision. In that agreement, which again is a part of the record, the Walthall specifically provided that land had to be restricted, that the purpose was to create and maintain a high quality subdivision.
Excuse me for interrupting,
Yes,
counsel. With reference to those transactions, those transfers of title, were the nature of the restrictions different in those two transactions?
The restrictions in the Axley deed, which was the first off conveyance, are identical to the restrictions in the Riley deed, what my client's deed. And when they made the off conveyance to Sharp, they did not include those specific restrictions. The language in the agreement simply provides that the intent is to create a high quality residential development.
So the restrictions in the Sharp deed were different than the Axley deed?
Yes, yes. Excuse me. In 1993, the Walthalls conveyed 16.72 acres to my clients, the Rileys. The conveyance to the Riley is what created the express restrictive covenants. And in this deed, where the restrictions are, as I stated, identical to the ones in the Axley deed, the Walthalls went further and stated that these restrictions apply to the land herein conveyed and to the land of the first parties. Now, The argument by the defense, accepted by the court, was that this was not a sufficient definition of what land was to be included. My position is, if you simply go to the Riley deed and read it in its entirety, it tells you what is included. For this reason, the Walthals identify themselves as the first parties in the introductory portion of the deed. You get down to the end of the description, and it states that it's a meets and bound description, and it states that it's made by the survey. And again, these are Walthal's documents that are being prepared by Walthall for the conveyance. And it says a copy of said survey is attached hereto and made a part hereof. The survey that's attached to the deed identifies the Walthall property by name and designated by arrows, and provides that it's a property that the Walthals acquired and recorded in deed book 4U, page 62. The next paragraph of that deed, the derivation clause, again says that this was acquired by them and recorded in deed book 4U, page 52, in the McMinn County Registrar's office, and that says, to which reference is here made. So the Walthals are specifically referencing in this deed the land that they acquired and recorded in deed book 4U. The next paragraph is a one-line sentence identifying the parties, and then the very next sentence says it's understood and agreed that this conveyance is made and accepted, and the realty is granted upon and subject to the following covenants, restrictions, reservations, and rights, so forth, which run with the land conveyed herein and the land of the first parties. Now, I respectfully submit, may it please the court, that if you just look at this deed in its entirety, you look at the survey, which is adopted by reference. The survey identifies the land of the first parties as that being recorded in deed book 4U, page 62. There can be no question about what Walthall was intending to restrict.
Excuse me for interrupting
Yes,
again, counsel. At the time of the Riley deed, had the Walthalls reacquired some lots or property?
No. Well, I say no. When they made the agreement with Sharps to develop the Wheatland Hills subdivision, that agreement provides that Sharp would plot off 2 50-foot right-of-ways, which would allow Walthall to get from the Wheatland Hills subdivision back into this the residue of the 174-acre tract. Once the Wheatland Hills subdivision was complete, I believe at that time, and prior to the Riley deed, I don't remember the date, but Sharps did convey those 2 small 50-foot strips back to Walthall.
The survey that you referenced in the Riley deed, did it depict or identify these properties that were reacquired from the Sharps?
No, this was only a portion of the 174-acre tract that plotted off the 16.72 acres acquired by Riley. I stand corrected. I'm looking at this survey right now, which is attached to the Riley deed, and it does show lot 5A, which was one of the 50-foot strips provided for in the agreement and between Walthall and Sharp. And the other small 50-foot strip is lot 8A, and it does not appear on this survey. And on this survey that's attached to the Riley deed, it's got Bacon Walthall, deed book 4U, page 62, and then it's got arrows pointing to different portions of the property. Let me move quickly. I'm running out of time here. Let me move quickly to the second argument, which is the negative reciprocal easement theory. The trial judge found that there was no common plan. Every case that I read does not talk in terms of common plan. It talks in terms of a general plan or a general scheme. And I submit if you take the Axley deed, the first deed in 1986 that specifically sets out all these restrictions, and provides that the purpose of the restriction is to maintain the tone of the community, the beauty of it, to protect the property values. Then you go to the 1986 agreement, where they agreed to sell the 42 acres of Sharp, and that agreement they provide that the seller's desire to assure the high quality and require at least the following minimum restrictions. Then the next step is the Riley deed, which has the same exact descriptions as the Axley deed, with the same intent, the same purpose, to maintain the tone of the community, to protect the property values. And reading these instruments together, I would submit there can be no question that he did have a general plan, a general scheme to create a high-quality residential area in this part of Maine County. Now, if you go to the last deed in 1994, and I submit that this is significant, that Walthall conveyed the balance of the property he had at that time to his heirs, and that's collective G. And in this deed specifically, he's basically saying, heirs, we got this from our parents in 1955. We sold off some. This is what you're getting. And they put the same exact description, the 174-acre description that appeared in the original 1955 deed, and provided that there is accepted therefrom, from this 174 acres, the three specific off-conveyances which I've mentioned, the 7.29 acres to Axley, the 42 acres to Sharp, and the 16.72 acres to Riley. And then it says in capital letters, all of these exceptions are subject to various reservations, rights of way, and restrictive covenants as are created in the deeds and are hereby transferred to the grantees, transferred in capital letters to the grantees or trustees from whom this property is vested. I think when you look at all of these documents together, the intent of Walthall is clear. When you look at the deeds to Riley, the intent is clear. The Walthall property is adequately described to enforce the express restrictive covenants. The elements, a few minutes left, or a few seconds left, but the elements for negative reciprocal easement are common grantor, and that's not disputed, that they had a general plan. The court did not say they didn't have a general plan, didn't have a common plan. In my view, there's a big distinction. But these documents show that there was a general plan to create a high-end residential area. The common grantor must have intended for these covenants to benefit those. The documents themselves say that they're there to protect the value of the property. The last element is notice, and notice is imposed upon the defendant as a matter of law. I've used my time. Thank you.
You have your time. Excuse me. You have your time for rebuttal. We'll hear from the appellee.
May it please the court. My name is Richard Graves. I represent Appalachee River Valley Ag Credit ACA. Mr. Jimmy Mitchell represents Hector Jaramillo, and please forgive me if I pronounce the name wrong. Mr. Mitchell is going to speak to the implied easement arguments. I'm going to speak with respect to the express easement arguments.
All right, how much time?
We're going to split half and half, so when it hits 8 minutes, I'm going to step down and let Mr. Mitchell talk.
That's fine.
Put simply, I think this express easement claim is a relatively straightforward issue. And I think that the plaintiffs fail to not only state a claim, but their claim fails for two reasons. First, the express terms of the Riley deed simply do not restrict the land that the defendants currently own. And second, the Riley deed, to the extent it does create a restrictive covenant, it describes the defendant's property as the land of first parties. And that's not a sufficient description to satisfy the statute of frauds.
Does it refer to a survey, the deed?
The deed does refer to a survey to describe the land conveyed therein to the Rileys. And so the Riley deed contains a meets and bounds description. It references the survey attached. the survey shows, a complete closed description for the Riley tract. Now, the survey references property adjoining what I'll call the Riley tract, and does contain some deed references. And it does reference, what we have described as the parent tract deed in our briefing materials.
Is the parent tract shown in its entirety on the survey?
It is not, and I think that, and if the language of the Riley deed, for instance, said that the covenants run with the land herein conveyed and the land retained by first parties, I think that would be a sufficient description that it intended to describe the land and the parent tract deed that the Rileys retained at that time. Now, I do think it's notable that when we talk about the language of the land with the first parties, what we're really doing is identifying the parties to this restrictive covenant, because a restrictive covenant requires two parties, and they have to be two specific tracts of land. The land that's entitled to enforce a covenant is the dominant estate. The land that's subject to the restrictive covenant is called the servient estate. And for a valid restrictive covenant to apply to land, whether a dominant or servient estate, it has to sufficiently describe them both, because the parties or the owners of the land need to know what land is subjected to a restrictive covenant.
Excuse me for interrupting, counsel. The survey that has been referenced, did it depict all of the land, the real property owned by the Walt Halls at the time of that Riley conveyance?
It did not. It shows a portion of the parent tract deed, but doesn't show how expansive it is. It shows Lot 5A of the Wheatland Hills subdivision, which was owned by the Walt Halls at that time. And the source of that property ultimately goes back to the parent tract deed. And to digress for just a moment, I know that the plaintiffs have characterized the deed back into the Walt Halls as merely being a right-of-way. And certainly that tract of land is the subject to a right-of-way. But if you read that deed, it's Exhibit 6 to the defendant's statement of facts. It conveys a fee simple interest. Somebody, whatever easements are applicable to a certain tract of land, somebody has to own the underlying fee simple interest. And the deed back into the Walt Halls conveyed the entirety of the interest in those lots, subject to the right-of-way. But back into the idea of the parties to a restriction does not have to be mutually applicable. It can be a one-way restriction where one tract of land is entitled to enforce a restriction to another tract of land without that restriction having to be mutually binding on both parties. And
what tract of land could enforce the restriction against the Rileys?
And so that, carrying our contention to its logical conclusion, I don't think this deed sufficiently describes land of the first parties. And so I don't think the restriction is valid under the statute of frauds. If the restriction isn't valid under the statute of frauds, there's no specific tract of land that could enforce it against the Rileys. But it also, couldn't be enforceable against any of the land that the defendants own currently.
That the restriction just fails.
Correct.
All right.
Now, that's not an issue before this court or before the trial court, or was it?
I think it's, we raised this issue before the trial court. I think that's likely a natural implication. We did add as defendants everybody who claims title under that parent tract deed. So they're all before the court. I think that implicitly is within the province of the court to rule, though I don't recall us specifically praying for any relief that deed be declared void.
That was not raised as an issue before the trial court, or was it?
Only to the extent it's an implication of the statute of frauds argument. It wasn't raised as a standalone claim, to my recollection, that we prayed for declaratory relief that the restriction overall is void. As to the actual scope of the restriction, I think this is a relatively straightforward argument. The law in Tennessee with respect to the interpretation of restrictive covenants is well settled and has been for some time. And, we cite the Tennessee Supreme Court case of Shea v. Sargent in 1973, which I think, as good as any case, summarizes the rules the court must apply. That case, like here, involved a claim that a restrictive covenant prohibited certain activity on a piece of property, and the trial court and the Tennessee Supreme Court held that it did not. And in dealing with that, the Tennessee Supreme Court laid out the principles, which I'll repeat momentarily. And these are not direct quotes, but generally restrictive covenants are in derogation of the right to use property. Therefore, they have to be strictly construed and will not be extended by implication to anything not clearly and expressly prohibited by their terms. A restrictive covenant should not be given a construction which extends it beyond the literal meaning of the terms. And the court need not go beyond the face of an instrument's wording itself to find what the clearly expressed intention of the parties is. And when the meaning of a covenant is reasonable and unambiguous, there's no need to seek clarification outside its language. Applied here, the deed defines first parties as the grantors, the Waltals, defines the second parties as plaintiffs Joel and Mila Riley, and then the substantive restriction says in the event second parties desire to subdivide their land, they can only subdivide it in accordance with various restrictions the deed places on it. So the literal meaning of the substantive restriction at issue in the heart of the case is as simple as it only applies to the land of second parties. And thus, putting aside the description of the statute of fraud issue, the substantive restriction is not reciprocal. It's not mutual. It only burdens the land of the plaintiffs. And if the court were to construe it to also apply to additional land, well, then we've expressed that covenant beyond its clearly expressed terms. We've extended that covenant beyond the literal meaning, which is just contrary to the rules applicable to restrictive covenants in Tennessee. I see my time is winding down, so I'm going to yield the rest to my co-counsel, Mr. Mitchell.
Good morning, Your Honors.
Good morning.
Please the court. I'm Jimmy Mitchell from the Minden County Bar, and as Mr. Graves mentioned, I'm going to address the plaintiff's implied negative reciprocal easement argument. As Mr. Graves discussed, and as we discussed in our brief, Tennessee law favors the free use of property. So while negative reciprocal easements are well established in Tennessee case law, the courts have also consistently held that these easements should be applied with great care because they circumscribe the free use of property. If there are any ambiguities or uncertainties, then those should be resolved in favor of the free use of the property. There's 4 factors that must be satisfied to prove the existence of a negative reciprocal easement. Mr. G's already gone over those, so I'm not going to restate them, but the 2 I'm going to focus on are that the common grantor had a general plan for the property involved, and that the grantees had actual or constructive knowledge of the restrictions whenever they purchased their parcels. The trial court held that the plaintiffs failed to show the existence of a common plan for the property. And given the facts of this matter, that is the only logical conclusion. A common general plan for property requires that the land comes with restrictions designed to put into place a general plan of development. As the Tennessee Court of Appeals explained in Massey v. Graff, the motivation behind this doctrine is that when a purchaser buys land subject to restrictions imposed to carry out a general plan of development, the purchaser is then entitled to assume that all the land in the development will be similarly restricted to carry out that general plan.
Counsel,
Yes, Your Honor.
again, I apologize for interrupting. Is there a distinction between a common plan and a general scheme with reference to the issue in this case?
I believe that they're interchangeable, that they imply the same thing, that there is some plan of development being put into place. The Massey Court went on to say that since this doctrine undercuts the statute of frauds and creates uncertainty in land titles, it should only be applied when the existence of a general plan is clear and establishment is necessary to avoid injustice. There are several ways to show evidence of a general plan of development, and one of the most common ways is looking at the deeds from the common grantor. A number of the cases cited by the plaintiffs in support of their claim use this analysis. In my review of those cases indicated that they all serve to bolster our argument that in this case, there is no general plan. For example, in Laughlin v. Wagner, there were 35 lots sold and each deed contained the same or similar restrictions. In Ridley v. Heyman, there were 49 lots sold, and each deed contained the same restrictions. And in Land Developers v. Maxwell, there were 29 lots sold, and each deed contained the same or similar restrictions. In this case, we only have 2 deeds from the common grantor containing the same restrictions, which is just not enough to prove the existence of a general plan. And there are other ways to establish evidence of a general plan of development, but none of those are present in this case either. Common grantors did not plan any sort of development. They were not developers. They did not file a master deed or a declaration of covenants and restrictions. They did not prepare or record a plat showing any restrictions to the property, nor did they prepare any sales brochures, maps, or advertisements showing a general plan of development for this property. Instead, in this case, the various sales of the property from the parent tract do not indicate a common plan because each distinct sale imposed different restrictions. The conveyance to the Axleys contained a covenant restricting the lot sizes to 1.5 acres each. The next conveyance to the Sharps of a 42-acre tract contained no restrictions in the deed, but instead an entirely separate agreement with the Sharps, allowing them to subdivide their property up to an average density of 1 dwelling unit per acre. Next conveyance to the plaintiffs contained the same restriction as the Axleys in that lots could not be subdivided less than 1.5 acres. And then finally, whenever the common grantors conveyed the remainder of the parent tract to their heirs through gift deeds and warranty deeds, they did not include any restrictions in those deeds. The trial court found, we believe to be correctly, that this lack of uniformity clearly shows that there was no general plan for the property. I don't think there's any evidence of a general plan, but there's certainly nowhere near enough evidence to meet the high burden of showing clear evidence that a general plan existed. The fourth prong of the test for an implied negative reciprocal easement requires that the grantees had actual or constructive knowledge of the restrictions when they purchased their parcels. The defendants did not have actual knowledge of the alleged 1.5 acre lot size restriction because no such restriction appears on their deed. In regards to constructive knowledge, the well-established standard in Tennessee is that when anything appears that put a man of ordinary prudence on inquiry, the law presumes that such inquiry was actually made, and whatever is sufficient to put a person upon inquiry is notice of all facts to which the inquiry will lead when prosecuted with reasonable diligence and in good faith. As the plaintiffs noted in their brief, in Ridley v. Heyman, the Tennessee Supreme Court stated that when one buys into a high-class neighborhood where there are no business houses, he has a duty to inquire about possible restrictions, and the purchaser cannot willfully close his ears and shut his eyes. In this case, open ears and open eyes would not put the defendants on inquiry notice because of a negative reciprocal easement restricting lots to 1.5 acres, because the restriction does not appear uniformly among the other sales and transactions. At the time the defendants purchased their property, there were the following tracts immediately around it that had originated from the parent tract. There was the Axley's 7.29 acre tract with the 1.5 acre restriction, the Sharps 42 acre fully developed subdivision with no 1.5 acre restriction, the plaintiff's 16.72 acre tract with the 1.5 acre restriction but with 2 residential structures on the premises, a .5866 acre tract owned by the Hamiltons with no restrictions, and a 10.1 acre tract owned by the Heaters with no restrictions. It's just not reasonable to say that this lay of the land should have put the defendants on any kind of notice that they should investigate further and that there might be restrictions on the property that they were purchasing. And given these facts, it's our position that the plaintiffs cannot prove that the defendants had actual or constructive knowledge of the 1.5 acre lot restrictive covenant that they seek to enforce, and therefore their claim must fail on that basis as well. Thank you, Your Honors.
Thank you. Here for the appellate and rebuttal.
Briefly in rebuttal, Your Honor, I'd ask this simple question, just logic and common sense. If Walthall had not intended that these restrictions apply in the Riley deed, why would he put it in the deed? Now, why would this deed say that the restrictions set forth herein and to run with the land conveyed herein and the land of the first parties? Why put it in there if he did not intend for this to be restricted? There would be no reason for it. Mr. I'm sorry, that's not correct. I'll just say Mr. Graves argued that the restrictions in this deed, the Riley deed, only apply to the Rileys. But again, that's what the deed says, that it applies to the land of the first parties. And this survey that we've talked about shows the Bacon Walthaw, and it's got deed book 4U, page 62. And the law is clear. I've cited this in my brief, the case of Harriman Land Company versus Hilton, that when a deed makes reference to other instruments, deeds, maps, that may be looked to determine the sufficiency of the description. What could be more definitive than saying, you look to deed book 4U, page 62? I submit it could not be more defined. With regard to the statement by Mr. Mitchell, with regard to the negative reciprocal easement, and all of you have heard this before, but it's also referred to as an equitable servitude. What's fair? Is it fair for a grantor to restrict the use of this property the way he's done here and then sell off some acreage for chicken houses or anything? And in this particular case, the proposed lot development size, and I've attached this to the appendix, is 6/100ths of an acre to less than a half acre. I strongly urge the court to set aside the ruling of the lower court and to grant the plaintiff a summary judgment. In my view, the facts, the law, and common sense dictate that result. Thank you all for your time.
Thank you. Court's thanks to counsel for both sides. We appreciate your oral arguments today and the briefs.